feel to to discuss, to take. So today I'm here to take the class for the UGC, the UGC examination, uh, and I'll be discussing some of the important and we are active in UGC examination class. So what I've been given here is I'll be taking classes on commercial law. Then we'll move on to public international law, after which we'll be in jurisprudence, and finally we'll move on to environmental law. So at previous classes, I actually started my classes from the first module. I started my classes from the first module, that was commercial law. And we discussed a lot of acts within the commercial law, which included the contract act. We started my class from the contract act 1872. Then we moved on to certain other acts, including the partnerships act, negotiable instruments act. And today, I'll be discussing, so further in my class today, I'll be discussing the so today I'll be discussing the Limited Liability Partnerships Act of 2008, and so just a minute before we begin. This is my topic for today. And this kind of limited liability partnership, we look into this act came into being in the year 2008. And it is limited liability partnership. The entire concept is kind of like a worldwide recognized public business. It's not just it's not a novel concept. It is already something that is already speaking. Is that has came into as an act. And if we look into the specifications of this act, LLP, the concept of LLP, yeah, so the said act, yeah, so the said act, what we have to understand for this very concept is that it actually is a combination. So it's actually a combination of both Companies Act as well as Partnership Act. It's kind of like a combination of both these, which is formed into a single organization, and so it is also a way to relieve a person from the traditional concept of partnership. So what the said thing is that from the entire traditional form of partnership, the problem with the said thing was that it kind of had an unlimited liability. So all the partners in the said
concept in the said partnership. In the traditional concept of partnership, all the partners, they just had unlimited liability for all the debts and obligation. So if in a partnership any sort of debt or obligation, if it comes forth, in such a situation all the partners would be equally held liable. But the said concept received a parallel change. It received a major change with the Limited Liability Partnership Act. So as the name has it itself, as in the traditional partnership form it was unlimited liability, here in the said act it is limited liability given to the partners. And we are moving on. Let's move on to the next slide. That is the characteristics of the said act. So it is governed by the LLP Act of 2008, and it is kind of like its characteristics involved. It is a body corporate. It is a legal entity that is separate from its partners. It has perpetual succession, and it can own assets, it can sue, and it can be sued. So all these, if we look into these aspects, we can see that it is strikingly similar to that of a company. So it is strikingly similar to the concept, to the features of a company. That is, it is a body corporate, separate legal entity, perpetual succession, has its own assets. So these are all similar to the concept of company, but still it comes under the concept of partnership with certain other features that it has adopted from the Partnerships Act. So the partners here, they actually manage the business directly. If we look into a company, we can see that there are broadly two types of there are various other members within the company, but broadly speaking there are two types. One is the shareholders, and then there is the directors. So it is the directors who actually manage the company, while the shareholders, they actually, what they do is that uh, they actually owns the company. Shareholders, they owns the company, and the directors, they actually manage the company. So this is what used to happen. This is what a company, that's how a company runs. But in the Partnership Act, in the Limited Liability Partnership Act, we can see that the partners, they themselves manage the entire business directly. That too directly they manage the said business. And one partner here, so one partner is not responsible for the act of just a single partner. One partner itself will not be liable for the for another partner's misconduct or negligence. So if any sort of misconduct or negligence happens from another partners on behalf of other partners, the said partner, one partner, he cannot be held responsible if it is for the misconduct or negligence caused by some other partners. Then, for the said act to come into force, to come into effect for a said partnership firm, then it must at least have, the minimum number of partners is 2. At least it should have 2 members as its partners, and there is no set maximum limit for the same. And the said LLP, Limited Liability Partnership, it should come into effect for conducting of a business. It should come into force so that a business could be conducted properly and efficiently. So the entire concept, the entire LLP is subject to a said business, for the performance of a said business. And also the rights and duties of the partner will be actually governed by the agreement between the partners, and the partners have flexibility to devise the said agreement as per their choice. So all the rights and liabilities of the partners will be clearly stated in the partnership agreement, and as they find it flexible, as per the flexibility of the partners, they can actually devise the agreement as per their convenience, as per their choice. That's to do with the characteristics of the said act. Moving on to the concept of partner. Who is a partner when it comes to a limited liability partnership? So the concept of partner is basically discussed in section 2 clause Q of the LLP Act, and in the said section we can see the concept of partner, the said definition. It states as follows: in relation to a limited liability partnership means, partner in relation to a limited liability partnership means any person who becomes a partner in the limited liability partnership in accordance with the limited liability partnership agreement. So whoever becomes a partner to the firm as per the LLP agreement is deemed as a partner, and this is mentioned in section 2 clause q of the LLP Act. So what you need to do here is you have to memorize the said sections 2 clause q. When it comes to UGC net examination, what you need to have a clear understanding of the sections as well as its description. So what is actually measured in the said examination is your precision. You have to always be precise on what you learn. So whenever you learn a topic, you should not go broadly into the topic. Just dealing with the topic in a broad sphere is not going to help you prepare for this particular exam. You need to have a precise knowledge on which section it is dealt in, which is the corresponding description of the section, what all are mentioned in the section, the chronology of the following, the chronology of the things that are mentioned in the section. All these aspects are of high importance when you are preparing for your UGC net examination. So here just remember the section 2 clause q defines partner in an LLP in the LLP Act. Now, process of formulation of LLP. How an LLP is formulated. Here, the first first thing you have to understand is it is capital contribution. There is a capital contribution. So each partner here contributes to the said partnership. That is, partners are required to contribute to the LLP. So here the concept of share capital is void. There is no concept of share capital is absent here. The concept of share capital is absent. Instead, each partner that contributes to the said LLP. So the contribution can be made either in the form of a tangible asset or it can be through an intangible asset. And monetary value of each partner's contribution must be accounted for, and it will be disclosed in the LLP's financial statement. So the financial statement of the LLP will have the clear-cut description as to the monetary value that each partner has contributed to. Then a designated, who is a designated partner. So every LLP have at least 2 designated partners. So every LLP will be having 2 designated partners, and these partners must be individuals, and at least one of them must be a resident in India. So the entire concept of designated partner is actually discussed in section 7. So I mentioned earlier, it is vital for you to understand, from the examination point of view, it is vital for you to understand the sections. You have to have a clear-cut information as to which section describes what. So section 7 is of importance. You have to understand section 7 describes a designated partner. Now there is the DPIN, designated partner identification number. The said number is discussed in section, the said aspect is actually discussed in section 7 clause 6 of the LLP Act, and every designated partner, as per which every designated partner should have a designated partner identification number, that is the DPIN, and this DPIN is actually given by the central government. It's the central government who issues the said DPIN. Let's move on to the next topic, that is digital signature certificate. So it is a digital signature certificate not just for partnership. Digital signature is of a huge importance. DSC is actually of a huge importance in today's day and age, because everything happens in an online form where all the contracts, most of the contracts of the government contracts, everything happens in an online medium. So earlier, if we look into the history of the said thing, we can see there were telegraphic signatures. Then it moved on to certain other changes that happened over the years, and now we have presently the digital signature and also electronic signatures. And digital signature is actually used to validate the identity of an individual online. So whatever document a person signs in, a signature is actually a sign of validity. So a document, when signed, it actually gives a validation to the said document. It becomes authentic. So to maintain the said authenticity even in the online platform, the technology has introduced digital signature certificates as well as electronic signature certificates. So these two aspects are of really great importance, and we will deal with this in the Information Technology Act, which we have to analyze for said examination, for the present examination that we have at hand. So in the LLP Act, the DSC is of importance because its primary function is to digitally sign electronic documents, and it ensures the authenticity and integrity. So at least one of the designated partner must obtain a DSC for giving out clear documents, clear authentic electronic documents. DSC is of huge importance. Now, the LLP name, Limited Liability Partnership, it must have a name, the LLP name. It should represent the business. Whatever name the LLP holds, it should represent the business, and it should not be identical or similar to the existing names. So, it must be authentic and unique, and it must represent the said business. So, the LLP name, it must represent the said business. And what is an LLP agreement? LLP agreement is actually mentioned in section 2 clause O of the LLP Act. So the section is important. Mark the section 2 clause O. It is of really great importance. And as per the section, LLP agreement means any written agreement between the partners of the limited liability partnership, or between the limited liability partners and its partners, which determines the mutual rights and duties of the partners and their rights and duties in relation to that limited liability partnership. So it actually gives out, the agreement, LLP agreement, actually states the mutual rights and duties of the partners, whatever rights, duties they have for the partnership company, for the partnership business, as well as for the partners themselves, as well as between the partners themselves. So all the rights and duties are clearly stated in the said Partnership Act. Okay, so that is what the LLP agreement is. Let's move on to the next topic, that is the Companies Act. So Companies Act, so after discussing Companies Act is actually the last portion when it comes to the module of commercial law. In commercial law, we dealt with many acts, from Contract Act, Partnership Act, LLP Act, Negotiable Instruments Act, and finally we'll be dealing with the Companies Act of 2013. And for the examination point of view, Companies Act is of really great importance. When it comes to the module of commercial law, Contract Act is very much important, after which you have to give more emphasis, you have to give more importance to the Companies Act, because as per my research, I think Contract and Companies Act, these two acts have a greater weightage in the entire module of commercial law. So let's begin Companies Act for today. So Companies Act actually governs the registration, regulation, dissolution of companies. So various aspects of the company, which includes registration, regulation, and dissolution, all these are mentioned within the Companies Act. Then, as per the said act, the term company, the term company itself has gone through a lot of evolution of its own. So that is not important for the set examination point of view. So after a lot of discussions and debates, the entire concept of company, we can segregate the entire concept, and we can identify its features. Identify the features as the following, which includes the company. It actually is a separate legal entity. So first feature of a company under the Companies Act 2013 is that it is a separate legal entity. So a company, as we know, it has a lot of person within it: shareholders, stakeholders, directors, creditors. All these person comes under one umbrella, that is company, and all of them are of really great importance. All of them are needed for the proper functioning of the said company. And because of this, because all these persons are within the company, it is of really great importance for it to be a separate legal entity. So a company is a separate legal entity. This is the first and important feature of a company. Then separation of ownership and management. This is the next feature. The ownership and management. When it comes to a company, the ownership and management are two different things. This is different from the concept of partnership we discussed earlier. So in partnership, all the partners, they together owns and manages the company. But when it comes to a company under the Companies Act, it is owned by different person, owned by a person and managed by different person. So the ownership of the company is with the shareholders. So it is the shareholders who owns the company, and the management, the entire process of management and various other facts within the company, it goes to the directors. So shareholders and directors, they both of them together owns and manages the company. Then there is transferability of shares. So the shares that a company, so the shares within the company, they are transferable. Shares that the shareholders possess, it is actually transferable. So there is the transferability of shares. Then another feature is common seal. So the company is actually run under a common seal, and it is considered as an artificial legal person. That is, a company can enter into contracts, it can sue, and it can be sued in its name. So it is treated as an artificial legal person separate from its members. Now let's discuss the types of company that are within the Companies Act. Companies Act actually contains various types of companies, out of which we'll discuss these four. So the first company that Companies Act discusses is the private company. And the said company, private company, the term itself, it is actually defined in section 2 clause 2 clause 68 of the Companies Act. So the section is of importance. Note the section, and also you have to you have to note the numbers as well. In this category, when you learn these provisions, you will have to be clear about the sections as well as the numbers that it contains. If the section contains any numbers or anything that is to be arranged chronologically, anything that is mentioned chronologically, all these portions must be noted by you. So section 2 clause 68 actually defines private company, and as per the said section, it actually limits the number of members to 200. So the number of members within a private company is restricted to 200, and it restricts the transfer of shares. Transfer of shares are restricted in a private company. Under this category, it actually includes three categories. Private company actually includes three categories, which is limited by shares, then there is limited by guarantee, and unlimited liability. So there are these three categories within the uh, said act, and limited by shares. It actually means that a person will be liable to the shares that they have to the unpaid shares that they own. So limited by shares means they will be liable to the unpaid shares. Then there is the concept of limited by guarantee. Limited by guarantee is actually the liability being limited to a particular sum of money that they have agreed to pay if the business winds up. So that is what limited by guarantee is. Then there is unlimited liability. Unlimited liability means they will be liable even to the personal assets. So the person will be liable even to their personal assets, personal belongings. That is what unlimited liability talks about. So all these comes under private company. If we look into public company is actually defined in section 2 clause 71 of the Companies Act, and it actually restricts. Public company actually says that the minimum members must be 7. Must have a minimum number of members should be 7, and there is no maximum limit for the said public company. There are various other companies within the Companies Act, including a one-person company. So one-person company is actually discussed in section 2 clause 62 of the said act, and as per this act, it means a company which has only one person as a member. So as a member, there will be only one person Such company is termed as one-person company. Moving on to Section 8 company. So under this classification, this is an interesting classification for a company because such a company, Section 8 company, actually runs for a non-profit motive. They actually are more like they actually run for charitable purposes, or it can be to promote arts or sports. It also can be something of a religious purpose. So all these companies that are for non-profit motives. So the companies that are for non-profit motives, such companies are said to be Section 8 companies. Now let's discuss the topic of corporate veil. This is an important topic. This is a very important topic, corporate veil. Not just for the UGC net examination, not just in the UGC net examination point of view, but in general, the topic of corporate veil is of utmost importance. And the said concept, it actually separates the identity the said concept actually separates the identity of the company from its shareholders or members. So through this concept, the shareholders and members of a company is actually treated distinct, is actually treated separate from the is actually given a separate identity from the said company. So the company is identified as a separate entity from its shareholders or members, and it actually brings a barrier between the company as a legal entity and its owners. So the legal protection the legal protection that are given to the shareholder, it actually gives legal protection to the shareholders and shields them from the company's liability. So a company, while running a company, the company will have a lot of debts, obligations, and liabilities. So all these liabilities will be limited to the said company, and the shareholders are protected from these liabilities through the doctrine of corporate veil, through the process of corporate veil. Then, what happens? Why does this corporate veil gets lifted? So, at situations, the court can lift the said corporate veil if there are any fraudulent or illegal activity. So, lifting the corporate veil happens when the court actually, it's a process whereby the court pierces through the said veil. So, the court pierces the said veil to detect any fraud or illegal activity or any other consistency that are persisting in a company. So, to identify any fraudulent activity, the said corporate veil is lifted at times, and this initiative is taken by the court. So the entire concept of corporate veil was actually promoted in the case of Salomon versus Salomon. Actually, I am not discussing case laws right now because we have a lot to discuss in our topics. The case laws we'll be discussing when we are dealing with the question papers. What I'm going to do here is just to refresh. The thing that I meant to do here is to refresh your memories so that we can so that when we go through the question papers, you find some familiarity with it. And because the topic is so important, I'll be discussing. I'll just give you a memory boost on what the case of Salomon versus Salomon is. So it actually dealt with a boot or shoe company, which the said Salomon owned, and the company actually, he was the proprietor of the company when it began, but later, due to the debts and obligation, he actually became a shareholder. So the company, through time, the company actually became insolvent, and here the creditors. So the case is that here the creditors wanted to make Salomon personally liable. But the court here held that because Salomon actually was a shareholder, and the concept of corporate veil was brought in. So Salomon was a shareholder, and he had a different identity from that of a company. So because of that, Salomon could not be held personally liable. It is a very important case when it comes to Companies Act, company law. When you are learning company law, it is of great importance. That is why I just mentioned the case. We will deal with the case when we are looking through when we discuss the question papers. The case laws will be discussed. So for now, we are just discussing the important topics within the said acts. Now, if we look into the concept of prospectus is an important document when it comes to Companies Act. Prospectus is an important topic not just for the UGC NET examination, but company law as a whole. Prospectus, memorandum of association, articles of association, these documents are of great importance when it comes to Companies Act. What is a prospectus? Prospectus is actually something that gives the investors a proper idea before they invest in a company. So it gives the investors with certain information which they want before making the decision of investing or not. Just to give them a clear-cut idea in order to make the investment. That is what prospectus is. So we'll discuss it. So a prospectus is a document including it can be, so prospectus is actually a document and it can be a notice, circular or advertisement. So all these documents, be it circular, notice or advertisement, all these can contribute to a prospectus. And whichever be in the document, it actually invites the public to subscribe to the securities of the body corporate. And the primary purpose of the said document is to attract the potential investors and give them proper information as to the company's finances, the plans of the company, the risks that the company has taken. So to give them all the information with regard to the company, uh, in order to facilitate them, in order to make them take informed investment decisions, in order to aid them to make an informed investment decision. That very document, the said document is a prospectus. And this section is important. Section 2 clause 70. Section 2 clause 70 actually deals with the term prospectus. Prospectus is defined in the said section, and it means, prospectus actually means any document described or issued as a prospectus and includes red herring prospectus under section 32 or shelf prospectus under section 31, or any notice, circular, advertisement or other document inviting offers from the public for the subscription or purchase of any security of a body corporate. So that is what prospectus means. So prospectus is actually, I said, it is actually for the investors, so that they can analyze the company, analyze its risks, and make a proper informed decision. And there are various types of prospectus, including the ones mentioned in the definition, which is red herring prospectus, shelf prospectus. Other than this, there are various other prospectus as well, which includes uh, there are various other prospectus, red herring prospectus and shelf prospectus. There are abridged prospectus. So all these prospectus together helps the investors to make an informed decision for the said investment. So a red herring prospectus basically is actually used for a single IPO. It is actually for raising a single IPO. Red herring prospectus is used. On the other hand, if you look into shelf prospectus can be used for multiple public offering, for multiple offerings, for multiple public offerings. Shelf prospectus can be used, means can be reused for various other circumstances, for a many period of time. So it can be used for over a period of time, while red herring prospectus is actually limited to a certain IPO. There is also the concept of abridged prospectus. It actually gives a concise summary of the entire prospectus. Abridged prospectus is like a summary to the entire prospectus. So that is what the concept of prospectus is within the Companies Act. Then these sections are of importance. Section 32, section 31. You have to understand the sections and its corresponding details when you are learning. Now moving on, let's move on to the next topic, that is memorandum of association. This topic is really crucial because once we are studying Companies Act, we always find people misunderstanding or mistaking the concept of memorandum of association with articles of association. People find it quite difficult to understand these two concepts, to distinguish these two concepts. It's kind of hard for certain people. They actually get confused. So today, just let me give you a proper way to identify these two documents, because when a company, because in a company, memorandum of association and articles of association, these two documents actually form a company. To make this concept more interesting, to make this concept seep into you, I'll just give you an example. Like, imagine you are building a house, and the first thing you need before building the house is a proper plan, is the proper blueprint as to where the kitchen should be, how many floors the house should have, and where the dining room should be, where should be the main hall, where should be the office. You will have a clear cut idea, clear cut blueprint of the uh, said house. So the set concept, the entire concept of blueprint in a house, if you bring the set concept into the corporate world, it is similar to that of a memorandum of association. You can say that it is a blueprint of the said company. It actually lays down the foundation. Memorandum of association is the foundation of a particular company. Now, it is under section 4. Memorandum of association is actually discussed in section 4 of the Companies Act. And if we move on to section 2 clause 56, it actually defines memorandum, defines what memorandum actually is. It actually means memorandum of association of a company as originally framed or altered, or as altered from time to time in pursuance of any previous company law or this act. So that is what memorandum of association. So it is under it is under section 2 clause 56. Memorandum is actually discussed. If we look into the contents of the said memorandum, we can see there will be a name clause, there will be a registered office clause, there will be object clause, and there will be liability clause, and there will be certain other aspects to the said memorandum of association, said document of memorandum of association. Now, what is articles of association? This is also another important topic, and to segregate these two, memorandum of association, MOA and OA, to segregate these two concepts, articles of associations are basically, so through memorandum, giving you an example, memorandum of association was connected to the blueprint of a said house. On the other hand, articles of associations are basically something that you can connect it to the house rules. So once the house is built, a person will be having a lot of house rules within the said house as to where the uh, shoes are allowed in the house or not, pets are allowed in the house or not. There will be certain rules and regulations after you build a particular house. So the said rules are mentioned in the articles of association, which are mentioned in section 5 of the said act. So articles of associations are basically rules and regulations of a particular company. It actually deals with rules and regulation, and as per section 2 clause 5, it actually defines what articles is, and the definition clause, it actually defines articles as articles of association of a company as originally framed or as altered from time to time, or applies in pursuance or of any previous company law or this act or of this act. So basically it actually contains preliminary information that specifies the amount of share capitals, voting rights, transfer of shares. All these aspects will be defined in section through the articles of association. Now, if we look into the doctrine of ultra vires, there is the said doctrine of ultra vires, and ultra vires, this doctrine is of high importance when you study company law. This doctrine is of great importance. So ultra vires actually means going beyond the powers that are given to a particular entity. So if you go beyond the powers of, if a company goes beyond its powers, it is considered as ultra vires. And so these powers and objectives, it will be mentioned in the MOA, that is memorandum of association. And if the company acts beyond these powers, it will actually be ultra vires. So all these act which goes beyond the powers as specified in the MOA, it will be considered void. So remedies that can be given in such situation includes injunction, nullity of contract, compensation, etc. So all these remedies can be given in such situation for ultra vires, for an act which is done ultra vires to the powers given to a particular company. Now, avoidance of fraudulent use. This is the major objective for bringing the entire doctrine of ultra vires. So, the doctrine of ultra vires is actually brought in so that the company will not engage in any fraudulent or any unauthorized use. So, that is what the doctrine of ultra vires deals with. Uh, Now, the important aspects of company law is meetings. So today in my class, I have only discussed the important sections of company law. There are many other important facts, important aspects of the said act, and we will be dealing with all these aspects while we are discussing the question papers. So as of now, we will be discussing just a few important topics that comes under the Companies Act, which includes the following. And today we'll start with and we'll move on with the concept of meetings. So what are meetings in a company? So meetings are basically of two types. Basically, categorizing meetings, it can generally be of two types. One is board meeting, the other is general meeting. So board meeting is defined in section 173 of the said act. These sections, when you study meetings, when you are studying meetings, sections and the days that are prescribed in the said act, the time period and the days that are mentioned in the act are of importance. You have to understand, you have to identify the set dates and also the sections corresponding to it. So while learning the sections, mark the dates, mark the time frame. The time frame of every meeting. Time frame of every meeting is of importance. You have to study the sections along with the time frame of the said act. Board meetings. Board meetings are discussed in section 173 of the Act, which is important. Section 173 deals with board meetings, and the name has its board has it itself. Board meeting. The term board is within the set concept. So it is a meeting of board of directors. So a meeting consisting of board of directors is known as board meetings, and these meetings are often conducted so that operational and strategic matters can be discussed. The company can review its strategic or operational matters and related things and other related matters. So for this, board meetings are brought in, and these meetings are held in every 3 months. So this time frame, 3 months, every 3 months, board meetings will be held in every 3 months, and the gap between the time period should not exceed 120 days. So it should happen in every 3 months, and the gap between two consecutive meetings, it should not be more than 120 days. So within a 120-day time frame, the meetings must be conducted. Then there is general meeting. General meetings are of different categories, which includes annual general meeting, extraordinary general meeting, class meeting, and meeting of creditors. Annual general meeting is something that is to present. This is a meeting that is hosted to present annual financial statements of a company. So to discuss the financial statements of a company, to declare dividends and various other matters, the annual general meeting is held. So this is held in every this is held once every calendar year within 6 months from the end of a financial statement. So the time frame here, that is 6 months. So the time frame is of importance. So the period of 6 months. Sorry, I was trying to mark this, but yeah. So the time frame of 6 months is of importance, and the said concept, annual general meeting, is actually discussed in section 96 of the Companies Act 2013. So sections along with the time frame is important. Then there is extraordinary general meeting. Extraordinary general meeting is discussed in section 100 of the Companies Act. This is easy to remember. Extraordinary general meeting, section 100. So extraordinary meetings happen when there is any urgent matters that are to be discussed within the company. So if we have special or urgent matters that is to be transacted, extraordinary general meetings are called upon. And a minimum 21 days of notice must be given for the said meeting. So minimum 21 days of notice must be given, and it can also be held on a short notice if all the members have consented. So basically, when extraordinary general meeting happen, it must happen within 21 days. 21 days of notice. And it is mentioned in section 100 of the Companies Act. Then there is the class meeting. Class meeting is actually conducted for a particular class of shareholders. As we know, there are different types of shareholders, and this includes preference shareholders, equity shareholders, and there are various other shareholders. So class meeting is conducted for particular class of shareholders. So all these class of shareholders comes together for the class meeting. Then there is the meeting of creditors. Creditors meeting. When creditors come together, creditors hold a meeting. That is a meeting of creditors, and it is mentioned in section 230 of the Companies Act. So this meeting actually occurs when you have to consider and approve a particular scheme or arrangement within a set company. So for approval of considering schemes or arrangements of a company, such meetings of creditors are held. Then the most important topic in Companies Act, the most important one with respect to UGC net examination, the most important section is section 135 of the Companies Act, which deals with corporate social responsibility. So for UGC net, even for the previous years also I have seen question papers that have discussed the CSR, corporate social responsibility. I think it was last year or before last year, it was asked. The said question was there in the question paper, and you have to analyze this section. You have to analyze everything within this section. There are various other clauses, but due to the due to the time restraint that I am actually discussing only the first few portions of the said section, which includes so section 135 is basically section 135 is basically, it actually deals with corporate social responsibility, and it is actually a business model. Corporate social responsibility is actually a business model that actually makes an effort to operate in a way to enhance the society and environment. So since the corporate that is a company, it actually operates within a society. It operates within the society, it contributes to the people within the society, and corporate social responsibility actually enhances the said view. So companies, they actually have a corporate life, they actually follow a corporate method, so they actually are considered rather degraded in the society. So to elevate from that, move on from the said concept, corporate social responsibility is introduced. So here, every company having net worth of 500 crores or more. This is important. 500 crores. You have to understand. You have to learn this through the uh, set section. Set sections, and also the figures given in the set section is important. 500 crores. That is the net worth. So net worth being 500 crores, and turnover, the turnover of the company must be rupees 1000 crores. Turnover 1000 crores, net worth 500 crores or more, and a net profit of 5 crores. The net profit must be 5 crore or more. This is important, and you have to memorize it chronologically. That is, first comes the net worth, that the turnover is discussed, that net profit is discussed, and also the figures that corresponds to it. 500 crores net worth, turnover of 1000 crores, net profit of 5 crores. This chronology is important, and a company satisfying the said concept, the company that satisfies the said aspects, it should constitute as corporate social responsibility committee. So the company satisfying the said concept must constitute a committee of board. It should constitute a committee, and it must consist of 3 or more directors. It should consist of 3 or more directors, out of which at least one director should be independent director. It should consist of 3 or more directors, and one director must be an independent director. At least one director should be independent director. Now, this is the final section. This is the final section that we'll be discussing today, which is the winding up. Uh, this is the final section that we'll be discussing today. That is the winding up of companies. So winding up basically happens. It can happen in two ways. That is through voluntary winding up or compulsory winding up. Voluntary winding up actually is when members they voluntarily winds up the company. That is, if the company is solvent, that is in such situation the company is actually solvent and the debt can be paid within 3 years. So it is in this situation when the company winds up voluntarily. So voluntary winding up occurs when members voluntarily winds up the company and the debts will be paid within 3 years. Just note the year for considering the viewpoint from the examination point of view. Just note the year here, 3 years. Within 3 years the debt will be paid in case of voluntary winding up. Then there is creditors voluntary winding up. So the creditors, the members actually resolve to wind up. So here the creditors, they actually resolve to wind up, but the members actually resolve to wind up, but the director actually declare the debt cannot be paid in full. In such situation, so here the creditors will be involved. So if the director declares that the debt cannot be paid in full, then creditors voluntarily winding up process happens. Then there is compulsory winding up, when the company winds up compulsorily. Compulsory winding up happens through petition, through the court's interference, that is the NCLT or any other courts. Through court intervention when winding up happens, that is what compulsory winding up is. So this can happen through a creditor petition. So this can happen through a petition filed by the creditor in the NCLT, that is the National Company Law Tribunal, NCLT. The creditor can file the petition. Then there can be a contributory petition that can be filed by persons liable to contribute to the assets of the company in the event of winding up. So a person who is actually liable to contribute to the assets of the company when in the event of a company is winding up, in such situation, contributory petition can be initiated by the said person. Then compulsory winding up can also happen at the tribunal's own motion. So when through the tribunal's own motion, compulsory winding up can happen. That is, the NCLT itself initiates the said winding up process. So that is it. So this is what we will be discussing today. So these are the set topics that I'll be discussing today. So further in the next class we'll be discussing public public international law, and so the next class we'll be discussing public international law, and after that we will move on to the rest of the chapters, that is jurisprudence. We'll discuss jurisprudence and various other concepts, environmental law also. So with the Companies Act, we are closing. We came to an end of our first module, that is the commercial law. So the commercial law was our first module, and the Companies Act, what we discussed today, the Companies Act is actually the final section, and with this we have come to an end of our final module. So thank you for listening. If you have any doubt, please post it on the comment section, and I'll be discussing it in the further classes.